Hello, friends, and welcome to the official YouTube channel of TechSaj, where we share with you all types of legal, taxation and financial matters. तो लीगल स्टडीज़ के इस न्यू चैप्टर में आपका स्वागत है, वेयर यू विल डिस्कस अ कॉन्सेप्ट दैट इज अ सिविल कोर्ट शैल हैव jurisdiction टू ट्राई ऑल द सूट्स ऑफ अ सिविल नेचर। इस कॉन्सेप्ट पे आज हम डिस्कस करेंगे। तो जैसा आपको पता है कि जो हमारा टॉपिक होता है ये एक राइटिंग पॉइंट ऑफ व्यू से हम देते हैं, सो दैट यू कुड हैव अ बेटर कॉन्सेप्ट अबाउट राइटिंग एंड अंडरस्टैंडिंग। पॉइंट वाइज डिटेल्स दिए गए हैं सो दैट इट विल बी ईजियर फॉर यू। और ये पीडीएफ का यू विल गेट अ कॉपी ऑल्सो। आपको जस्ट कमेंट बॉक्स में जाके अपना नाम, कॉलेज का नाम एंड ईमेल आईडी प्रोवाइड करना है, एंड वी विल मेल यू द कॉपी विथ द डिस्क्रिप्टिव नोट्स जो इस पर हम डालेंगे। ठीक है, तो आइए चलते हैं, पढ़ते हैं इस नए टॉपिक को। सो द टॉपिक इज लाइक द सिविल कोर्ट कैन ट्राई ऑल सूट्स ऑफ सिविल नेचर एंड इट्स jurisdiction इज ऑफ 4 kinds। डिस्कस। या फिर ऐसे भी आ सकता है कि अ सिविल कोर्ट शैल हैव jurisdiction टू ट्राई ऑल द सूट्स ऑफ अ सिविल नेचर अनलेस बार्ड, या फिर एक्सप्लेन द टर्म सूट्स ऑफ अ सिविल नेचर इन द प्रोविजन। क्वेश्चंस किसी भी टाइप के आ सकते हैं डिपेंडिंग ऑन द यूनिवर्सिटी, डिपेंडिंग ऑन द टीचर। आपको राइटिंग अपने हिसाब से रखना है एक स्ट्रक्चर्ड मैनर में, लाइक आई हैव प्रेजेंटेड। आप यहाँ पे देख सकते हैं। सो लेट्स स्टार्ट। सो द आंसर राइटिंग शुड बी लाइक jurisdiction of a civil court according to section 9, the court shall, subject to the provisions herein contained, have jurisdiction to try all the suits of a civil nature excepting suits which their cognizance is either expressly or impliedly barred। इस पॉइंट से हमें समझ में आता है कि सिविल कोर्ट को जुरिस्डिक्शन है हर एक टाइप का सूट इनिशिएट करने का, विच इज इफ नॉट एक्सप्रेसली बार्ड। एक बार फिर से देखते हैं। जुरिस्डिक्शन ऑफ अ सिविल कोर्ट अकॉर्डिंग टू सेक्शन 9। सेक्शन हम याद करेंगे, ये एक ज़रूरी चीज़ होती है। jurisdiction of civil court according to section 9, the court shall, subject to the provisions herein contained, have jurisdiction to try all suits of a civil nature excepting suits which their cognizance is either expressly or impliedly barred। कहना क्या चाहता है, इसका मतलब देखते हैं एक्सप्लेनेशन पॉइंट से। A suit in which the right to property or to an office is contested is a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of question as to religious rites or ceremonies। दूसरा एक्सप्लेनेशन देखते हैं। For the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to in explanation 1 or whether or not such office is attached to a particular place। एक्सप्लेनेशन पॉइंट ऑफ व्यू से ये दोनों पॉइंट्स वाइटल हैं। Now we look over to the conditions. A civil court has jurisdiction to try a suit if 2 conditions are fulfilled. Condition 1, the suit must be of a civil nature. Point 2, the cognizance of such a suit should not have been expressly or impliedly barred। तो पहला पॉइंट देखते हैं, सूट ऑफ अ सिविल नेचर क्या कहता है। In order that a civil court may have jurisdiction to try a suit, the first condition which must be satisfied is that the suit must be of a civil nature। But what is a suit of a civil nature? The word civil has been, the suit civil has not been defined in the code, but according to the dictionary meaning, it pertains to private rights and remedies of a citizen as distinguished from criminal, political, etc. The word nature has been defined as the fundamental qualities of a person or thing, identity or essential character, sort, kind, character. It is thus wider in content. The expression civil nature is wider than the expression civil proceedings. Thus, a suit is of a civil nature if the principal question therein relates to the determination of a civil right and enforcement thereof. It is not the status of the parties to the suit, but the subject matter of it, which determines whether or not the suit is of civil nature. Point 2 देखते हैं. Nature and scope of suit of civil nature. The expression suit of civil nature will cover the private rights and obligations of a citizen. Political and religious questions are not covered by the expression. A suit in which the principal question relates to caste or religion is not a suit of a civil nature. But if the principal question in the suit is of a civil nature, like the right of property or to an office, and the adjudication identically involves the determination relating to a caste question or religious rites and ceremonies, it does not cease to be a suit of a civil nature, and the jurisdiction of a civil court is not barred. Each word and expression casts an obligation on the court to exercise jurisdiction for the enforcement of rights. The word shall makes it mandatory. No court can refuse to entertain a suit if it is of the description mentioned in the section, that is, amplified by the use of the expression all suits of civil nature. The word civil, according to the dictionary meaning, relating to the citizen as an individual, civil rights. Black's Legal Dictionary defines it as relating to provide rights and remedies sought by a civil action as contrasted with criminal proceedings. In law, it is understood as an antonym of criminal. Historically, the two broad classifications were civil and criminal. Revenue, tax, and company, etc., were added to it later, but they too pertain to the larger family of civil. There is thus no doubt about the width of the word civil. Its width has been stretched further by using the word nature along with it. That is, even those suits are cognizable which are not only civil but even of civil nature. Nature is defined as the fundamental qualities of a person or thing, identity or essential character, sort, kind, character. It is thus wider in content. The word civil nature is wider than the word civil proceeding. The section would therefore be available in every case where the dispute was the characteristics of affecting one's right, which are not only civil but of civil nature. Example of suits of civil nature. Suits relating to the right of property, suits relating to the right to worship, suits relating to taking out of religion's possession, suits relating to the right to share in offerings, suits for damages of a civil wrong, suits for specific performance of a contract or of damages for breach of contract, suits of a specific relief, suits for restitution of conjugal rights, suits for dissolution of marriage, suits for rent, suits for account, suits for a right of a franchise, suits for a right to hereditary office, suits for a right to yajmanvriti, suits against wrongful dismissal from service and for salary. अब देखते हैं एग्जाम्पल ऑफ सूट्स नॉट ऑफ सिविल नेचर. Suits involving principally caste question, suits involving purely religious rites or ceremonies, suits for upholding mere dignity and honor, suits for recovery of voluntary payment of offerings, suits against expulsion from caste. Point number 2, cognizance not barred. It is to be noted that a litigant having a grievance of a civil nature has a right to institute a civil suit unless its cognizance is barred, either expressly or impliedly. Suits expressly barred. A suit is said to be expressly barred when it is barred by an enactment for the time being in force. It is open to a competent legislator to bar jurisdiction of civil court with respect to a particular class of suits of a civil nature, provided that in doing so it keeps itself within the field of legislation confined to its charge and does not contravene any provision of the Constitution. Thus, the matters falling within the exclusive jurisdiction of revenue courts or under the Code of Criminal Procedure, or the matters dealt with by special tribunal under the relevant statute, example, by industrial tribunal, election tribunal, revenue tribunal, rent tribunal, cooperative tribunal, income tax tribunal, motor accident claim tribunal, etc., or by domestic tribunals like BCI, medical council, university, club, etc., are especially barred from the cognizance of a civil court. But if the remedy provided by a statute is not adequate and all questions cannot be decided by a special tribunal, the jurisdiction of a civil court is not barred. Similarly, when a court of limited jurisdiction prima facie and incidentally states something, the jurisdiction of a civil court to finally decide the time is not ousted. ये था सूट एक्सप्रेसली बार्ड. अब देखते हैं सूट impliedly barred. A suit is said to be impliedly barred when it is barred by a general principle of law where a specific remedy is given by a statute. It thereby deprives the person who insists upon a remedy of any other form than that given by the statute, where an act creates an obligation and enforces the performance in a specified manner. That performance cannot be enforced in any other manner. Thus, no suit shall lie for recovery of cost incurred in criminal prosecution or of enforcement of right upon contract hit by Section 23 of the Indian Contract Act 1872 or against any judge for acts done in the course of his duties, likewise political questions belonging to the domain of public administrative law and are outside the jurisdiction of civil courts. A civil court has no jurisdiction to adjudicate upon dispute of political nature. अब देखते हैं what is kinds of jurisdiction. A civil court has following four kinds of jurisdiction. Jurisdiction over the subject matter, local or territorial jurisdiction, pecuniary jurisdiction और चौथा है ओरिजिनल और appellate jurisdiction. एक एक करके पढ़ते हैं. Different courts have been allotted different types of work. A small causes court has the authority to try only certain suits of non-contentious types. Example, suits in respect of loans or promissory notes or bonds. Suits for recovery of the price of goods supplied to work done, but it has no jurisdiction to try suits for partition or for injunction for immovable properties or for specific performance of contracts. The district judge alone has jurisdiction in respect of testamentary and cases of guardianship. Second point, local or territorial jurisdiction. The territorial limit of the jurisdiction of a court is fixed by the government, and beyond that limit it has no jurisdiction. Thus, the district judge has jurisdiction within its district. The High Court has jurisdiction over its state only and not beyond. Municip's jurisdiction is also limited to a particular area. Pecuniary jurisdiction. Some of the courts are authorized to entertain suits or appeals up to a particular amount. Munsifs are generally authorized to entertain suits up to a value of 25,000 rupees in UP. The civil judges have jurisdiction for suits above rupees 25,000. The High Court has no pecuniary limitation. Some of the small causes judges are empowered up to rupees 10,000 and others only up to rupees 2,000. Where the government realizes any amount from a citizen that is not entitled to charge, he can file a suit for recovery of that amount in the civil court. मुन्ना लाल वर्सेस स्टेट ऑफ पंजाब, ये केस लॉ है, AR 1916. चौथा पॉइंट देखते हैं, ओरिजिनल और अपीलेट जुरिसडिक्शन. Some of the courts exercise only original jurisdiction. Example, the munsifs and the judges of the small causes court. The civil judges, district judges, and the High Court have been conferred appellate powers. So, this was all about सिविल सूट प्रोसीजर्स. इसके नोट्स अगर आपको चाहिए तो ये PDF फॉर्म में आपको मिल जाएंगे. यू जस्ट हैव टू राइट इन द कमेंट बॉक्स योर नेम, college name, or if you are a working employee then simply write job and your email address, and we will mail you the soft copy ASAP. So this was all for today. I hope you liked the video. If you liked the video, प्लीज़ लाइक, शेयर, कमेंट एंड सब्सक्राइब टू आवर चैनल. और आपको लगता है कि ये वीडियो आपके किसी फ्रेंड के काम आ सकता है तो उसके संग ज़रूर शेयर करें. थैंक यू.